hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning, everyone, and welcome to today's remote sitting of the Appeals Court. Let me begin by introducing the panel to you. I am joined today by Justice Jeffrey Kinder and Justice Young Shin. I think you both know me. My name is Ariane, you know. A quick reminder that the rules that apply to oral argument in the courtroom apply equally to this remote platform. So you're veteran litigators, you know you each have 15 minutes and you know that there is no rebuttal. And you will also know that we've read the briefs carefully and we're ready to hear your most important points. So with that said, I'm going to officially call the case. This is Commonwealth versus Robert Smith, 2019-1377. Attorney Taylor?
Thank you. Good morning. May it please the court, Susan Taylor for Robert Smith. Mr. Smith was convicted in the Berkshire Superior Court of leaving the scene after an accident causing a death, intimidation of a witness, burning of a motor vehicle, and destruction of evidence. On appeal, Mr. Smith raises three arguments. The first, whether or not it was error to admit a videotape which was collected from the area that the accident occurred in. And the objection, there was initially at the time of trial, there was no objection because at the time that the trial began, the Commonwealth had presumably in hand a witness who would authenticate the video. However,
it was the person, in fact, it was the person who actually had the video camera in his home, right?
Well, I'm not so sure. And I think that I actually think that's a little bit unclear because apparently it was a sharing camera between several different houses, according to the testimony. But I would suggest that that's exactly the problem here is that obviously, Officer Madalena, the person who actually testified to have the video admitted, was not a witness to the event. And while he can certainly look at a video and say that this is an fair and accurate representation of the particular intersection, there's other aspects of that video that I would suggest that he couldn't authenticate. So it was his testimony that he believed that the accident happened on a particular date in and around a particular time. And the video reflected that date and time. But there was no testimony as to where the camera was located. It was located in a house, but there was no testimony as to where.
Why is that significant in the circumstances of this case where you had an eyewitness who arrived just after the accident? In other words, somebody arrived at the scene having actually still seen the motorbike fall down, as I recall the testimony, right? And the judge had that testimony as well as having the voir dire testimony of the officer who obtained the tape and his viewing of it, and indicating that intersection now shows a body, unfortunately, and the bike. Very similar to what was witnessed or observed rather by the woman who came up to the intersection just after the accident. That wasn't sufficiently authenticated as far as you're concerned. What's missing there?
Well, so I don't think that the woman who came upon the scene, I don't think that she authenticated the tape in any way. I think that
she just simply described the circumstances of what you saw, and the judge then relied upon that in part to say that there was confirmatory circumstances in interval, right?
Well, yes, I would agree that her testimony corroborates in terms of the timing of the accident itself. But I would suggest that in this case, not only did Officer Madalena he didn't collect the tape himself. I mean, initially it would seem that he did. But it was later, we don't really know who collected the tape, when they collected it. And so in a time and age where people can make and manipulate images on tapes, I would suggest to the court that the the tape was not adequately authenticated prior to its admission. Unless the panel has any questions, I'll proceed to the next issues, which was whether or not counsel was ineffective for not requesting a instruction that the testimony of the immunized witness should be scrutinized with great scrutiny because that witness was immunized. So the judge in this case did give a general instruction about that particular witness and did speak to the fact that she was immunized. But in this case, the particular witness, just reading the testimony, she is a really difficult witness to read, much less, I'm sure, to examine. But her,
I guess you would say reluctant is an understatement, huh?
yes, many times. And so I don't think although I understand that when you're trying a case that there's a lot going on, but in this particular case, there just would not be any tactical reason not to ask for such an instruction.
If we assume for just a moment that the instruction should have been requested and should have been given, in light of the fact that there was at least a version of the Champa instruction given immediately, and that the witness's testimony was pretty forcefully challenged in argument, why should we conclude here that the instruction would have made a difference?
Well, I would suggest that the case law is such that when a particular instruction is given to a jury, that it's presumed that juries follow instructions. And although there was the most general instruction in that regard, in this particular case, the Commonwealth was really allowed to ask this witness directly without objection from the defense counsel whether or not she was telling the truth. He vouched for her and her testimony because she basically, and he suggested that she was immunized, she had nothing to lose, and that, and I would suggest to the court that it might have made a difference. And finally, the last issue that I have raised in my brief was whether or not the consciousness of guilt instruction should have been given. So the Commonwealth requested that instruction, and to the effect that there's an inference that can be drawn from evidence of flight, concealment, similar acts such as false statements to the police, destruction or concealment of evidence. And ordinarily, if we were only talking about a case where the defendant was charged with leaving the scene and the issue in the case was purely the identity of the offender. In this case, unfortunately, because he was charged with those other offenses, the intimidation, the burning of the vehicle, and the withholding of evidence, what it does is, I mean, Judge Mason did try to be careful in this regard. I mean, he did give a specialized instruction with regard to consciousness of guilt, recognizing that for him to instruct that if you find that the defendant in any way suggested or told the witness to lie, that you can use that as to create an inference that there was some consciousness of guilt. So what is basically substantive evidence on the last three counts is basically used as to create an inference in the leaving the scene count.
You referred in your brief to the language of the consciousness of guilt instruction given as inflammatory. What exactly was it in the nature of the instruction that you find inflammatory?
Well, my verbiage of inflammatory is perhaps not appropriate, because what it does, though, is it creates a situation where I would suggest that the court is suggesting that, although it's almost like argument, that to suggest that there is evidence that this defendant instructed Ms. Gerwitz to lie to the police, to say that he was with her at the time that this offense occurred. All of that, I think, creates almost an inference that the court is accepting her testimony that he did those things. And that's the danger of it. And I would suggest in these cases, they really didn't even need a consciousness of guilt instruction. It wasn't necessary. If the trier of fact accepted that he did these things, that he asked her to lie, that he told her to go to the police station and say that she was, if he did those things, then I would suggest that an ordinary juror would believe that that was some sort of inference that there was a consciousness of guilt without actually having the stamp of approval by the court by the giving of the instruction.
I guess your description of it in those terms brings us back to the prejudice question. If a jury would naturally infer that in any event, where's the prejudice involved in giving the instruction?
Well, that I would suggest that giving the instruction is sort of the a priori kind of planting of this basically gives the stamp of approval by the judge that these are the facts, and if you find these facts, you can infer that he is also guilty. Well, that he also has a consciousness of guilt about some particular, about count one is really what it comes down to. And unless the panel has any other questions, I will rest on my brief.
I have no further questions. I see no questions from the panel. Thank you very much, Attorney Taylor.
You.
Attorney Greenbaum.
Can you hear me?
We can.
Well, I have the Commonwealth. I will rest on my brief and attempt to answer any questions if the court has them.
Okay. I'll ask the panel. Justice Kinder, any questions for the
Yes.
Commonwealth?
I do have a question. Do you agree, Mr. Greenbaum, that the instruction that was given stopped short of the Champa instruction in its entirety?
It did, yeah, it did not quite cover it totally, but the Champa instruction isn't a required instruction. I mean, the exact language isn't required. Some sort of instruction is required. And I believe between what he gave, both contemporaneously with the instruction about care taken and listening to an immunized witness and the final instruction was adequate in terms of drawing the jury's attention to this witness, given also the fact that, as you saw, the whole nature of this witness's particular testimony and her grappling with the lawyers for both sides, in particular the prosecutor, whatever. I don't think there'd be any, even if one found that it wasn't quite totally adequate, there was any chance of prejudice that the jury somehow would have not taken into account the fact that she had something at stake in terms of being immunized. And as I also point out, she's not a percipient witness to any of this. Well, she has strong circumstantial evidence on the destruction of evidence and other facts and the burning of the car or whatever. But overall, as I said in my introduction, the strength of the case against the defendant outside of Ms. Gerwitz's testimony was pretty strong. The DNA evidence that put him in the car, put the victim's blood on the car, put his DNA on the cigarette that was attempting to burn the vehicle. So yes, it doesn't prescribe particular words. I'm not going to argue that it's as good as Champa, but under the circumstances of this case, if it wasn't, I believe it was sufficient, and if it wasn't, there's still no prejudice.
I'll see. Justice Shin, do you have any questions of the Commonwealth?
No, thank you.
Okay, no, and Attorney Greenbaum, I have no questions.
And we are live.
Thank you very much. Good morning. Thank you for participating in today's argument via this remote platform. It's very helpful for us to be able to do it this way, and we appreciate your patience with us if need be, and we'll be patient with you with the technology if need be as well. Let me introduce the panel. I'm joined today by Justice Jeffrey Kinder and Justice Sukyoung Shin. As you know, or likely know, the same rules of that apply to oral argument in the regular courtroom apply to this platform as well. So you each have 15 minutes and there's no rebuttal in the appeals court. I'm going to call the case, Commonwealth versus Kirk Austin, 2018-1145. And we'll begin with Attorney Rotundo.
Good morning, Your Honors. Attorney David Rotundo for Mr. Austin. The first issue in this case is regarding the excessive prior bad acts that were brought up during direct examination of the complainant witness. And we agree that prior bad acts are admissible to show the nature of the relationship between the parties, and that the bad acts would help explain why the complainant in this case would recant her testimony. But it's our position that it was an error for all these bad acts to come out on direct examination. There was, at that point, the complainant hadn't recanted any of her testimony. And only after the complainant's testimony do we get, after that full round of direct examination, do we get our first limiting instruction. So, and also I'd like to kind of bring in my argument that regarding the leading questions. Due to the excessive prior bad acts introduced, it's our position that trial counsel was forced to acquiesce to the use of leading questions in an effort to minimize the prejudicial effects. So, and I think we're in agreement with regards to the level of prior bad acts that came in this case. And I defer to the Commonwealth's brief, pages 19 to 21, essentially outlining the bad acts that did come in, uncharged conduct, and also reference to the numerous restraining orders. So that's essentially that.
If I could ask a question. You mentioned that it was error to allow evidence of other bad acts before there was any evidence of a recantation. Doesn't the judge have the discretion to admit other bad act evidence to establish the nature of the relationship, period, whether there's been a recantation or not?
Yeah, I believe so, Your Honor. That is true. However, in this case, I would argue that due to the excessiveness of the bad acts, more were allowed than were necessary to show the nature of that relationship.
So are you suggesting that although some bad acts may have been admissible, the volume was not?
Yes, Your Honor, that's essentially our argument.
All right, you may proceed.
If I move on to the next argument two, this was our argument was that the judge erred when she denied the request for the lesser included instruction on count 7. That was assault and battery, serious bodily injury. The judge initially stated that such an instruction was supported by the facts. However, she declined to give it when the Commonwealth did not request it. Now, there was testimony by the complainant that the scar did exist under her eyebrow, and this scar apparently existed over it occurred over 6 years ago. So there was no indication during the trial that this scar was presented to the jury in any respect, or was included in any types of medical records.
Let me ask you a question about that, Attorney, if I may. So are you saying that the jury, in your view, were not able to see the scar themselves, and it was not visible to them while the individual was testifying?
I don't believe it was. I mean, I didn't, in my review of the record, there was no indication that this scar was purposely shown to the jury, or that there was any indication other than her testimony that this scar existed.
Well, the Commonwealth has argued in its brief that one reason for that potentially is that the fact that there was a scar was almost conceded by the defense, that it was not really pushed in any way. There was no questioning about it. Two other witnesses also mentioned the fact that there was a scar. What do you say to that?
Well, I mean, that brings me to the main issue. I realize that the case law requires that the element that distinguishes the lesser included offense from the main offense be sufficiently disputed. So the question is, what constitutes sufficiently disputed? And I would point to the Commonwealth versus their case, 418 Mass 130, which stands for the proposition that disbelief of a portion of the Commonwealth's evidence may, under certain circumstances, provide a basis for a lesser included offense. And I would suggest that the evidence supports the lesser included where the judge stated on the record that the jury could see or not see a scar. The scar was under the complainant's eyebrow. The scar was allegedly found over 6 years ago. The record did not indicate the complainant's scar was shown to the jury. And again, with regards to the medical records, it doesn't appear that there was any medical records.
How do you explain the fact that trial counsel did not do anything to dispute the existence of the scar? Did not question the witness about it or anything of that nature?
He didn't, but I would argue that he shouldn't have to bring attention to the scar, and the fact that the evidence, the jury was free to believe or disbelieve that portion of the evidence. So, and I believe that without the lesser included, we didn't have that situation.
Mm-hmm.
That's really all I have on that issue. Is there any other questions?
So, Thayer, the case you just cited, that was the case, I understand, where the defendant was challenging the judge's decision to give the instruction, not to omit the instruction. So aren't we dealing with a different standard in that situation?
Well,
in other words, the universe of cases where the judge can give the instruction is larger than the universe of cases where the judge must give the instruction. And here, given the absence of a factual dispute on the differentiating element, how is it error for the judge not to give the instruction?
Well, I think she wanted to give the instruction, but I think it's error when the Commonwealth said, we don't want it. That's when she made her decision not to give it. So I would say that the judge, in her discretion, felt that the instruction was necessary.
Okay.
I'm going to move on to argument 4. I also have a separate argument regarding the lesser included, regarding leading questions, but I think I've already covered that in my first argument.
Perhaps you want to direct your attention to your argument with respect to the instruction to the jury regarding the scar of the mark. Mm-hmm.
Yes. Next, the next argument is the judge's instructions to the jury regarding scars and marks. And she instructed scars or marks resulting from cuts that have been healed are still permanent because they are visible as long as the victim lives. It's our argument that that instruction relieved the government of burden of proof on that element. And I would suggest that the instruction directs the finding of scars or marks. And I would propose if that instruction was prefaced by language that say, if you find scars or marks in this case, then scars or marks resulting from et cetera, et cetera. So I would argue that that type of instruction would be proper. However, this type of instruction, I would argue that it directs the jury and removes that element from their consideration. Further, there was an error in the jury instruction, and I pointed that out in my brief. It was a possibly a Scribner's error. However, there was a missing from that instruction was or before impairment of a bodily function. So the way the jury heard that instruction, it's our position that it would require them to find impairment of a bodily function, because the instruction was missing that quote unquote or in it. So
Well, what was it? There wasn't really any evidence of impairment of a bodily function, was there?
no.
Okay.
No, there was not. And I would argue that because the instruction was missing that language, that the jury would have to find an impairment of a bodily function, simply because the instruction was incorrect. And law of the case in the jury instruction, they would be required to find impairment of a bodily function. And in this case, it's precisely correct. There was no impairment of a bodily function. Therefore, that count should have been, the jury shouldn't have found it guilty on that count because of an improper jury instruction.
I'm not understanding your argument, counsel. Are you saying that the evidence was insufficient on this charge because the instruction should be read as a containing an and instead of an or?
Yes, precisely. That's the argument, that there was no evidence to show impairment of a bodily function, and the way the instruction was presented to the jury, as I read it, would require impairment of a bodily function.
But as you read it, is it fair to say, I think you said yourself, that argument is based on a potential Scribner's error? In other words, what else leads you to believe that that was how the jury heard the instruction, other than that point that you're making right now?
Well, I have no.
Because there was
entirely
no
correct.
evidence, there's no evidence of it. Nobody argued that. There wasn't.
No, Your Honor.
Yeah.
No.
Okay. So there wasn't any other argument and an opening or a closing or implication that anybody was, the theory of the case had to do with impairment of the bodily function, right?
No, Your Honor, there was not.
Well, let me ask you this. Let's say that hypothetically that we agree with you that the instruction with respect to scars or marks was incorrect. All right. Can you even if that were the case, what is the prejudice that how can you point to some prejudice given the fact that the scar presumably was visible to the jury?
Well,
I mean, what effect did that instruction have on the jury in your view?
well, I would think that if the instruction is read the way I'm arguing it, that because of the error, the jury would have had to find impairment of a bodily function, which they couldn't because there was none. So, in essence, it would have there wasn't sufficient evidence.
No, let's say hypothetically we agree with you that the error had to do with that additional sentence regarding scars or marks, not the missing or, okay? So if we agree with you that that sentence was legally erroneous, what is the prejudice given that trial counsel did not contest the existence of a scar?
Well, if he didn't contest it, I would argue it would be on the substantial risk of miscarriage of justice standard that, the jury, they misread the instruction, and law of the case would be the instruction required impairment of a bodily function, and it was missing in the evidence. Therefore, they should not have convicted on that count.
And the remedy would be what, in your view? If we were to agree with you,
Vacate the conviction on that count.
entirely, not remand it for a resentencing on the lesser included?
Well, I would leave that to your discretion, Your Honor.
What would you prefer?
I would prefer that it be vacated.
Okay.
However, I do understand that maybe maybe a better course would be to have it remanded to determine if that was a Scrivener's error or not.
Mm.
So that's all I have on that issue. Argument 5, I took a look at the Commonwealth's rebuttal, and I realize that has to be raised as an affirmative defense, the statute of limitations argument. So I think I would just rely on my brief on that argument.
Okay. Well, your time is actually up, but we asked you a number of questions. I don't want to cut you off. Is there anything else you want to tell us, or you feel comfortable relying on your brief?
Yes, thank you.
Thank you very, very much. Attorney Rawl?
Thank you, Your Honor. Good morning. May it please the court, Ryan Rawl for the Commonwealth on behalf of Middlesex County. Your Honors, the Commonwealth asserts that you should affirm the convictions in this case. First, because the trial judge did not abuse her discretion in admitting the prior bad act evidence in this case for a variety of reasons. First, that it was highly probative evidence that was necessary to resolve a crucial issue in the case, the central theme of this case, which was the credibility of the victim on various fronts. And contrary to Attorney Rotundo's argument, this was raised right from the beginning in the opening statements. Questions about the victim's credibility was raised right from the beginning by counsel, and the case law, including Commonwealth versus Hall, allows the court's discretion to admit prior bad acts when it's clear at the beginning of the trial, allowing it in the Commonwealth's case in chief, when it's clear at the beginning of trial that there's a resultant need to rehabilitate the victim that will come forward.
Mr. Rawl, do you agree with the general proposition that other bad act evidence, if relevant, still can be limited in volume if at some point the inflammatory nature or the prejudicial impact of that testimony outweighs its proof regarding the nature of the relationship? In other words, you can establish the nature of the relationship with a single other bad act or 2 or 3. Then there is a question of volume.
I agree with that, Your Honor. I think 404B covers that, as well as the case law. In particular, Childs and Dwyer talk at length about the standard being whether it overwhelms the trial, so to speak, and causes a degree of unfair prejudice that outweighs the probative value. I think in this particular case, which had a unique set of facts and circumstances, a long-standing relationship between the victim and the defendant in a domestic violence situation, that it was important that selected pieces of prior bad acts were admitted from various parts of the relationship.
Why, for example, would it have been important after establishing the hostile nature of the relationship to introduce all of the prior restraining orders?
So there is case law point that points to the existence of the restraining orders. Not going into the detail of the content is helpful in understanding the full context and picture of a relationship. And I also think that on the particular aspect of admitting evidence of the existence of the restraining orders, that counsel cross-examined on that very point for the defendant and actually incorporated it into his defense, basically suggesting that every time she would file for a restraining order, she wouldn't go forward with the process. And she would get back together with the defendant, which led directly into his main theory, which is outlined in his closing, which is that the victim fabricates the allegations over a period of several years. This was a series of indictments, 11 in total, over a 5-year period, starting in 2010 and going into late 2015, in which there was a lot of evidence that supported a compelling narrative that the defendant would give. So I actually think it's helpful to look at this almost without the prior bad act evidence. What would the case look like in terms of the defense that was being raised? And what it would look like is 5 years of allegations of abuse that were not disclosed immediately, in which the victim had made inconsistent statements to DCF officials. There were 3 defense witnesses that were called on this issue, and then also had told police or lied to police specifically about 2 incidents. So it's difficult for a jury to be able to sufficiently understand the nature of this relationship. And I understand that this is more prior bad act evidence than's admitted in some other cases. I would acknowledge that. I think that this case in particular, given the high relevance of it, and also that there were 3 limiting instructions given at various points of the trial, that's on page volume 2, 90 to 91, volume 4, 109, and also in the closing charge from 145 to 146 in volume 5, and that the prosecutor properly argued this evidence, not just to show the nature of the relationship and the hostility of the parties, but what it really became was the crucial evidence to explain why the victim wouldn't have reported 5 years of continuous abuse, and why the victim would be make inconsistent statements and recant or say that such things didn't occur to DC officials and police.
Were the limiting instructions given by the judge on other bad act evidence the model instruction?
So I know that the model instruction was given in the closing. I believe that the instructions basically model the model instructions at the other 2 points, adding in the specific reason, which is consistent with the model instructions, the specific reasons of why the evidence is being admitted. So in this case, it was admitted for the victim's state of mind, the defendant's intent and course of conduct towards the victim, and the nature of the relationship of the parties. And so when you factor in, and you look at some of the other cases, such as Dwyer, I think it's important to look at this not from a number of prior bad acts versus number of charged incidents, although I know that's an important factor or consideration that's sort of discussed at length in Dwyer. But if you do look at that and you look at how I outlined the prior bad act evidence that was admitted, you see that in the victim's testimony, for example, a total of 18 pages is actually addressed using this, where 38 pages were addressed using the charge conduct. And you see that when you compare that to cases in which the prior bad acts have been found to overwhelm, it's not the number that matters, it's the amount of time that's dedicated in the trial and how it's sort of framed. So I would respectfully suggest that the way that this issue was framed to the jury was done correctly by the trial prosecutor in terms of how it was argued, and the trial judge did not abuse her discretion and commit palpable error by admitting this amount of prior bad acts when she was able to see and make sure that it didn't overwhelm the trial, give limiting instructions when appropriate, and try to minimize the prejudicial impact. So if there are no other questions on that issue, which I know is one of the main issues of the brief, I was going to move to the lesser included instructions. Okay, so on the lesser included instructions, in this case, the trial judge did not abuse her discretion in not giving the lesser included instruction, where there really was no factual dispute about the existence of the scar. And I think the case directly on point that's in my brief on this is Commonwealth versus Ortiz, which talks about in a rape indictment, how when there's no dispute about whether the specific type of penetration occurred or didn't occur, and it's simply an all or nothing sort of defense that the victim fabricated. It's not that she wasn't, or that it was not the person, as an example defense. Where the lesser included instruction isn't really a factual dispute, it shouldn't be given. In fact, case law suggests it's improper to give a lesser included instruction when there's no factual dispute about that particular element.
Counselor, could you, one moment, could you remind me, was there a motion for required finding with respect to the evidence of the scar of the serious bodily injury in this case?
So now that you say that, I don't recall there being a specific argument about the scar itself. I don't recall there being a motion for required finding where that was addressed, although I have to say that there's several volumes, so I can't say definitively, but I do not have any recollection of it being raised. I know that it wasn't argued in the closing argument at all to the jury. I know it wasn't cross-examined about, and I know that there was more than sufficient evidence, not only for the jury to see the scar, which was a small scar, but did remove some of her eyebrow.
Now, when you say more than sufficient evidence, and that's where I'm having a little bit of trouble, because there just didn't seem to be a lot of evidence. I think it's fair to say, perhaps just from my own point of view, that the issue is not contested.
Okay, well, I would say that when the victim testifies that she has the scar,
what can you point us to the?
Oh, I'm sorry.
I just said, what can you point to? She talked about it, but there's nothing in her testimony that indicates that she actually turned to the jury and showed it to the jury. We would have to infer, of course, that it was visible. Is that your point?
Sure, that's partially my point, but also my point is that there were also two other witnesses that also testified to the existence of scar and when it came about. So it came after the incident that was described.
Right, but neither of those witnesses testified that that the scar was still visible.
Yes, I guess that's true. They did say that the scar existed after 2010. They didn't specifically say that, but I also would point to case law. I note in my brief that even if the scar is no longer visible, the SJC has said that it still qualifies as permanent disfigurement.
So going to that part of the defendant's argument about the serious bodily injury instruction, the SJC has said that the jury can find a serious bodily injury even from scars that maybe have healed or scars that have faded. But doesn't this instruction convey the message that they must find serious bodily injury if they find that she has a scar? And why isn't that error?
So I first don't agree with the defendant's contention that this does that. I would respectfully suggest that the actual instruction simply provides a notation to the jury, which is correct as a matter of law, that scars are considered permanent because they might never heal or they will always be visible. But what the judge did not do is tell them that they had to find that the scar qualified as permanent disfigurement as an entire category, or that it had to qualify as serious bodily injury.
Mr. Rawl, let me interrupt with a question, if I could. You just said, I think, that that there is authority for the proposition that all scars can be considered permanent. I didn't find that authority. I do note that the judge in the charge conference did say exactly that scars are permanent, but I'm not sure that's an accurate statement of the law.
So I would direct you to page 46 of my brief, and I talk a little about this. I know that there isn't a lot of case law that speaks specifically to this point that's not unpublished opinions, because it's usually fact-specific inquiries about whether there's sufficient evidence of permanent disfigurement. But Commonwealth versus Farrell, which was a 1948 case, specifically said that scars in the victim's body will be permanent in the sense that they will be visible as long as the complainant lives. And that's a case that directly talks about how scars would qualify.
No, but the issue in that case was whether the jury could find disfigurement based on the presence of a scar. As Judge Kender pointed out, the judge seemed to believe that all scars automatically qualify as serious bodily injury. And I read this sentence that she added about scars to convey that message. And that seems to me to be a factual issue that should have been put to the jury, whether this scar qualifies as both permanent and disfiguring.
So I think that would be more akin to, there are other statutes where, for example, the assault and battery of dangerous weapon statute, where the judge is allowed to instruct as a matter of law that something is a dangerous weapon. And I would say that doesn't relieve in any way the Commonwealth the burden of proving that someone utilized a dangerous weapon to commit an assault and battery. And similar in other contexts, such as a subsequent offense, jury trial involving an OEY offense, the judge instructs as a matter of law that something is a like offense from an out of state as a matter of the jury instructions. And again, doesn't relieve the Commonwealth the burden of proving that.
But the statute doesn't say define serious bodily injury to include scars, right? I mean, if it said scars, then sure, no problem. But it says permanent disfigurement. So the jury has to find that the injury is permanent and disfiguring. And it's not just that scars are per se qualifying.
I understand what you're saying, Your Honor, and I think that the cases of Haywood and Farrell do make it fair to say as a matter of law that scars would qualify as being permanent. But even if the court found that this was an erroneous instruction, I don't think there's any prejudice that under whatever standard the court wants to apply that the defendant can point to where there was no, again, factual dispute about the scar and no suggestion other than by the defense that not that the scar didn't occur, but that it didn't happen from the defendant's actions. And so those are the two sort of options that were put in front of the jury. Did the defendant cause the scar, or was the scar caused by some other means and the victim was fabricating? There wasn't really a suggestion or argument that the scar didn't exist or that it didn't qualify as serious bodily injury throughout the entire
But it was not up to the defendant to have to argue that the scar was disfiguring. So it may very well be that the scar itself was not disputed, and that the evidence, even if we were accepting your description of it, was more than sufficient, I believe you said. The jury still has to find on its own whether that scar qualifies as permanent and disfiguring. So, I mean, not every single scar is that, right? I mean, you could have a scar that the jury might say, what might feel as if it was such a minor, that the visual effects of it were so minor that it wouldn't qualify. So how can, in that respect, then the jury in this case was not asked to make that determination? Do you agree?
Well, I think that when you read the entirety of the jury instructions as a whole, which did instruct them that they had to find factually, is that there was in fact serious bodily injury caused by a specific assault and battery incident, that I really don't believe that read as a whole, all the language of the judge's instructions, that it does cast it in such a way where it relieves the Commonwealth of its burden, as I sort of discuss in more detail in my brief, even if the court finds that the particular instruction either is erroneous or just didn't need to be given. If that's what the court finds, I still believe that the instructions as a whole didn't relieve the Commonwealth.
Your time is up, and I just want to check with the panel to see if they have any additional questions with respect to this. Attorney?
If I may ask one question, Judge Bino? Assuming that the instruction was erroneous, on the issue of prejudice, what option did defense counsel have other than arguing that the defendant didn't cause the scar? Right. So if he or she wanted to contest the element of serious bodily injury, perhaps they could have argued this scar doesn't qualify as serious bodily injury because it's faded. So it shouldn't be permanent. It's no longer visible. But counsel now knows that the judge is about to instruct otherwise. So what argument could counsel have raised to challenge that particular element?
Well, I'd start by saying that if counsel had in fact made an argument about it, he may have been able to convince the judge that giving the instruction was not appropriate.
Well, the judge had already made clear she was going to give the instruction. She said all scars qualify. So at that point, knowing that was the judge's belief, she was going to give that instruction. What option did counsel have to contest that element of the crime? How could you contest that element of the crime given the instruction?
Well, he could have disputed throughout the trial or during the trial by cross-examination of witnesses whether the scar was caused by that specific assault battery incident, right. Whether in fact, there was a scar that appeared in front of her. He could have argued that to the jury. She was in front of the jury. If it was a relatively small scar, he could argue that there's no evidence to suggest that was a scar in fact, but he didn't argue that. I mean, it's one thing to say that there was no factual dispute in the sense of, he didn't argue the scar wasn't serious bodily injury. He also didn't argue that there was no scar. He didn't argue that there was limited or insufficient information of proof of the scar. And if he did that, I think that still would have required the jury factually.
When you say argue, you mean in his closing argument, is that correct?
Yes, but also in cross-examination of the victim and other testimony of other witnesses about sort of whether this was a scar. I mean, there was no attempt to gather any information to show to the jury one way or another that a scar did or did not exist.
Let me stop you there and see if Judge Shin has any follow-up questions. No? Okay, sure. And
And we are live.
Thank you very much. Thank you both for your patience. It takes a couple of minutes for us to actually get onto the YouTube channel so that we can be observed by members of the public. Let me begin by introducing the panel to you. I'm joined today by Justice Jeffrey Kinder and Justice Suk-Young Shin. My name is Ariane Buno. Just a quick reminder that the rules of appellate procedure that apply to oral argument, as if we were in the courtroom, apply equally here. You each have 15 minutes and there's no rebuttal. I know that you both have argued before us numerous times. We're happy to see you again. And you also then know that we've read your briefs, we know the case well, and we look forward to hearing your most important parts of your argument. That said, I'll turn to you, Attorney White. Good morning, please begin.
Good morning. This is very new to me. May it please the court, I'm Jane Larman White. I appear today on behalf of D'Artagnan Pledger, who appeals numerous convictions, chief among them second-degree murder, concerning events on March 21st, 2016. The appeal presents a single issue for this court to resolve. That is that the defendant contends that there was no foundation for an inference of consciousness of guilt on his part, simply because he was in Georgia on August 31st, some 5 months after the crimes at issue. There was no evidence before the jury, as best I can see, as to when he went to Georgia. There was an affidavit which accompanied the defendant's motion in limine that explained when he went to Georgia on a bus, but that was not evidence before the jury.
I actually have a question for you on that. I'm going to preface my question with stating the number, the case number of this particular case, because I forgot to do that when we started. So we're talking about case number 2019-0828. I apologize. This platform is still somewhat new for us as well. But my question to you is this, and that is, there was evidence, wasn't there, as to when the last time your client was in Massachusetts before he went down to Georgia?
The last time there was
prior to his arrest in Georgia.
Well, there was evidence before the court that he had been, he had actually gone to the police station area B2 in early May, and that thereafter he had been in the presence of his half-brother and Lisa Lewis, the half-brother's girlfriend, when the police approached Lisa Lewis and gave her a document, which I think can be inferred was a grand jury summons. But I'm a little concerned about the court's inquiry that was the last time he was seen in Massachusetts. There was no evidence that he was under surveillance or.
Oh no, I didn't mean to. The question was in no way intended to imply anything. I just wanted to zero in on. You indicated there was no evidence as to how he went to his departure for Georgia, but there was some evidence with respect that he had been in Massachusetts in between the time of the murder and the time that the indictments were handed down. Right?
Yes, definitely. That was my only. But I think because the Commonwealth has contended and has actually argued to the jury that suddenly after the return of arrest warrants, and as to which there's no evidence that the defendant knew about them, that he left. But given that there's not any evidence before the jury as to when he left, the adverb "suddenly" when this happens is not applicable and is not supported by the evidence. Is my point.
Do you agree as a general matter, Ms. White, that the proximity in time between the charge and the defendant's subsequent arrest outside the jurisdiction has been considered admissible evidence and supportive of an instruction in other cases? That is, it's one factor that can be considered.
Well, I suggest that my reading of those cases, although there is that that announcement and that phraseology actually comes from Commonwealth versus Tony. And in the case of Tony, which of course was the big case about the proper instruction on conscience of guilt, the facts there were that the defendant had been absent from her usual environs for the 2 weeks immediately following the murder at issue, and that the police had looked for her at her home and at her work and had contacted various relatives. And so the defendant on appeal argued that even though that was so, she hadn't known that there was a warrant out. but the court specifically indicated that the Commonwealth's evidence was relevant to show that she was not at her home or at work during the 2-week period following the murder, and that was enough to establish its admissibility, even if she didn't know that they were looking for her. Now, that has been taken out of context, and a couple of cases from the SJC point out the necessity of the context for that. Those cases are cited in my brief. One of them is the case of Commonwealth versus Carry On, and the other one is the case of Barnowski. In Carry On, there was a discussion of a wanted poster, a flyer that seemingly identified the defendant within a month or so of the crime at issue, and that that this was said to be conscious of guilt because he didn't turn himself in, or that he somehow evaded arrest even though this poster was out there. And the court said that was not a valid basis because he had no knowledge of the wanted poster, so it couldn't have been conscious of guilt. Now, it was admissible for other reasons, but not conscious of guilt. And the fact that he didn't know about it was certainly the linchpin about the finding on consciousness of guilt. The other case, Barnowski, was one in which the defendant was told, I believe told, or at least it was going to happen whether or not he was told, that he was going to be tested for gunshot residue. And prior to being tested, he rubbed his hands through his hair. The defendant argued that this was not consciousness of guilt evidence, although that rubbing of his hair could have removed the gunshot residue from his hands, and that for that reason, it might be inferred that it was a consciousness of guilt. But the court held that the Commonwealth relying on that thing in pony, that language, that it doesn't matter what the defendant knows, it can be consciousness of guilt regardless of what he knows or doesn't know. And the SJC was very, very firm on this in footnote 9, that the defendant rubbed his hands through his hair is not consciousness of guilt if he didn't know anything about that test or that would have that effect. And the court specifically said that the Commonwealth is taking the language of Commonwealth versus Pony too far when it talks about the absence of knowledge, or knowledge is not the prerequisite invocation of the inference against a defendant.
As to the question of admissibility, before you get to the instruction on consciousness of guilt, we're talking about an abuse of discretion standard, correct?
No, we're not. In fact, that's extremely erroneous. That in the defendant's brief at 30 and 31, I cite the cases, primarily Stuckich, Stuckich, which is ordinarily cited for a different proposition, but it and cases which have followed it say explicitly that the standard of review is prejudicial error. If there's an inadequate foundation in the evidence before the jury to warrant that instruction, then it is an error of law to give it, because it tells the jury that there is such evidence and it can be considered.
I'm talking only now about the question of whether or not evidence of his arrest in Georgia was admissible.
Yes, and my answer is that it was not, that is the issue in this case. It has nothing to do with the appropriateness of an instruction on consciousness of guilt in the abstract. The defendant has made no argument that the instruction given the jury was anything other than what Pony recommends. The defendant is arguing and only arguing that there was no evidence to support that inference, and therefore it should not have been given at all. And
so your point is that the proximity in time of 12 days or so between the issuance of the arrest warrant and his subsequent arrest is insufficient as a matter of law?
Yes, without his knowledge of the existence of that arrest warrant. And this is not something that would have been difficult to prove. If the Commonwealth had, for instance, and there are cases cited in my brief in which this was the evidence, that the Commonwealth agents, police, had kept the defendant's or the defendant's home under loose surveillance and knew that he was present at home and in his usual environs up until the time of the arrest warrant, then that would show the nexus required. There's a case cited in my brief, which I'm not contending it controls here, but it does have, it's at least a CF for the proposition that the farther away the actions of the defendant are from the actual crime, the more essential is evidence that there was some triggering event to restore the proximity, and that proximity has to be established by evidence. The particular case is People versus Penzinger, and it's cited in footnote 15 of the defendant's brief. It talks about how in federal jury instructions, the requirement of knowledge by the defendant is only necessary when you get way out from the date of the crime itself.
But your client's knowledge, for example, the proof of knowledge at trial could be satisfied by circumstantial evidence as well. Maybe perhaps we were to agree with you, there was no direct evidence, but if there was sufficient circumstantial evidence, that could, the Commonwealth can meet its burden in that respect, correct? I'm not saying you agree there was circumstantial evidence. I'm just saying that circumstantial evidence could satisfy the Commonwealth's burden.
Yes, but here, Your Honor, that construct is purely circular. It sort of starts from the presumption of his guilt and then says that from that guilt, you could infer that he was aware of whatever the co-defendants were aware of when they were in first Connecticut and then Rhode Island. The specific evidence about those parties were that Lisa Lewis and Nico Kawan Pledger went to Lisa Lewis's half-sister in Connecticut in the middle of the night.
If the jury were to believe that the three of them committed this crime together, then it would not have been improper to infer that they would have discussed the situation thereafter. And when two of the three participants were found to have direct knowledge because of that evidence, you're saying that's too attenuated for the jury to infer that your client had knowledge as well? I know your answer is going to be
yes. And that was in fact recognized by the judge and is the law of the case. She said that those statements by Lisa Lewis, that she was aware of the warrants and was evading them, were admissible only as to her. I would point out that I believe they're admissible as to Nico Kawan as well, because his was an adoptive admission by silence. He was actually present when these statements were made by Lisa Lewis. There's no indication whatsoever that D'Artagnan Pledger was present or had any contact with them, frankly, since May, when he was seen in their company by the police. And as I say, it's a circular thing. By assuming guilt, you can bootstrap their consciousness of guilt onto him. And this is precisely what the limiting instruction was designed to prevent, and it's certainly what defense counsel at trial thought that he had. The judge did acknowledge that it was not admissible against D'Artagnan Pledger, but the Commonwealth's own closing argument made clear that it relied solely, it had to rely for the inference on the defendant's knowledge of the existence of the warrant. And my submission to the court is that that argument relied on two illegitimate suppositions. One was this assertion that suddenly after the issuance of warrant, he's gone. And as I indicated, that there was no evidence of that before the jury as to when he left the area. He could have left in June, he could have left in August before the issuance of the warrant. There's no evidence of that. And so the foundation is something that has to be presented. It's not up to the defendant to show the absence of foundation. The foundational requirement of relevance is on the Commonwealth. The other issue, the other proposition in the Commonwealth's closing argument, by which they're marshaling the only evidence they have to tag the defendant D'Artagnan with consciousness of guilt, was in fact this evidence about Lisa Lewis. I'm reading here from that closing argument. It says, and suddenly after August 19th, when these warrants issue, they're gone. And, you know, trial defense counsel raises a point. Well, how do you know that D'Artagnan Pledger knew that there was a warrant out? How do you know that he wasn't visiting some grandmother or some relative down in Georgia? Well, in isolation, that might be true, but look at it in the context of what the other two defendants do. And I submit to the court that that's precisely the use that was prohibited by the judge.
Putting aside the instruction that was given by the judge, what's wrong with that argument? I mean, why is it proper to argue that because the co-defendants knew about the warrant, it's reasonable to infer that the defendant did as well? What's wrong with that?
What's wrong with it is that the inference of consciousness of guilt is personal to a defendant. It's not something that is spread about.
But if the jury finds that these three defendants committed the crime together, and you have the statement of Lisa, which is admitted for her state of mind, once the jury uses that statement to find that Lisa knew about the warrants, why isn't it then a reasonable inference that the other two defendants also knew? I'm failing to see what's wrong with the argument.
It's wrong because it is so circular, and that consciousness of guilt as a proposition, and I believe if I haven't provided the cases, I can do so, that it is so damaging that it is personal to a defendant, that it is not something that a consciousness of guilt on the part of Lisa Lewis is attributable to any consciousness of guilt or motive or knowledge of the defendant.
It's not attributing her consciousness of guilt, it's attributing her knowledge. Once the jury uses that statement to find that she has knowledge of the warrants, which is a proper use of the statement, it seems to me proper to then argue that it's a reasonable inference that the other two defendants also knew about the warrants, because if the jury finds they committed this crime together.
Well,
but you would say that is not sufficient circumstantial evidence, I think is what you said, right?
That's not evidence.
But,
no.
But it is certainly, I understand your argument, but it is circumstantial evidence of knowledge. It may not be sufficient in your view, but at that bottom line, that's what it is.
I would have to disagree that knowledge of a different person in a different state 5 months after a crime is attributable to the defendant. I think that's just
that's because I think that we're using a different terms. You keep saying attributable to, whereas my question is whether or not it's just circumstantial evidence of knowledge, not that it's attributable to. But your time is up, and you've certainly answered my question. Let me check and see and be sure that you've answered Justice Shin's question as well.
I'm all set. Thank you.
Okay, Justice Kinder.
Thank you.
Thank you very much for answering our questions. I appreciate it. We'll turn now to Attorney Kesselheim.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. And I would also like to acknowledge the presence of Assistant District Attorneys Craig Iannini and Amanda Cassioni, the trial prosecutors in this matter, and of the victim's sister via the live stream today. The Commonwealth respectfully requests that this court affirm the defendant's convictions, where the trial judge did not abuse her discretion in admitting evidence of the defendant's flight to Georgia days after indictments issued against him in this case, and where the jury instruction with respect to that evidence and the prosecutor's closing argument, which mentioned that evidence, were both proper. And I think we start with what Justice Kinder was referencing earlier, which is the standard by which we judge the admissibility of the evidence. And that is indeed an abuse of discretion standard. And as the case law makes clear, and I'm citing to Booker, Commonwealth versus Booker, 386 Mass 466. It's a 1982 case. That case sets forth the standard for when consciousness of guilt evidence is admissible. And the judge has to determine whether the evidence is relevant, and then whether the evidence is so inflammatory in nature as to outweigh its probative value. And as subsequent case law makes clear, that initial analysis of the probative value of the evidence is a question of whether the evidence of flight is probative of feelings of guilt. It doesn't have to be proof that the defendant is guilty. Indeed, it can't be proof. It can't be the only proof that the defendant is guilty. But the question is whether the flight is probative of feelings of guilt. And that comes from Commonwealth versus Villafuerte, 72 Mass App Court 908. That's a 2008 case. Here, the judge did a careful analysis, not only of this evidence of the defendant's flight to Georgia, but also of two other pieces of flight evidence or potential flight evidence that were evaluated in this case. She clearly understood the balance that had to, the analysis that had to be done, whether the evidence was probative and whether it was unduly prejudicial. And in doing so, she did exclude other potential evidence of the defendant's flight in the immediate aftermath of the murder. With respect to the flight to Georgia, she found that the temporal nexus between the issuance of the warrant and the defendant's subsequent apprehension in Georgia was close enough to be probative of consciousness of guilt. After allowing that evidence in properly, she gave a jury instruction, which my sister agrees was a correct legal instruction on the permissive use of consciousness of guilt evidence by the jury, the way that the jury could properly weigh that evidence. That jury instruction comes from Commonwealth versus Tony and Commonwealth versus Stewart. Stewart is at 398 Mass 535. It's a 1986 case. The judge needs to instruct the jury that they are not to convict the defendant on the basis of evidence of flight or concealment alone, and that they may, but need not consider such evidence as one of the factors tending to prove to the defendant's guilt. And that is precisely what the judge did in this case.
Ms. Kesselheim, Ms. White suggests that a factor in the judge's consideration should have been whether there was some evidence, direct or circumstantial, of the defendant's knowledge of the existence of the warrant in order for the circumstances of his arrest to be put before the jury. Do you agree or disagree with that?
I disagree with that. The case law is clear. It's Commonwealth versus Tony, 385 Mass 575. It's a 1982 case. And that case specifically says the Commonwealth does not need to prove that the defendant knew of police pursuit at the time of flight for the evidence to be admissible. And further says that evidence that a person flees from his usual environs may be probative of a consciousness of guilt, regardless of whether he has actual knowledge that he is being sought by police. That comes directly from Tony. In this case, there was substantial evidence that the defendant was from Boston and that he was in Boston at the time of the murder and that he remained in Boston in the weeks after the murder, and indeed the months after the murder. That evidence came from several different sources. The murder happened on March 21st, 2016. His cell phone data showed, the data from the cell phone registered to him showed that he was in Boston at that time. A car registered to him with a Massachusetts registration is found at the scene with significant ballistic damage to the car. Inside the car is one of the guns used in the gunfight that resulted in the death of Alex Bryant and the wounding of Daquan Brown. Also in the car is the defendant's cell phone and his wallet. The wallet contained a driver's license and a Massachusetts ID card, both of which listed the defendant's address as 50 Evans Street in Dorchester. There was also a Massachusetts health card indicating that he was from Massachusetts. And the records, his cell phone records, which were also admitted in evidence, that was Exhibit 140, also listed his address as 50 Evans Street in Boston. So those are sort of pieces of evidence that the jury had before them, that this is a guy from Boston who lives in Boston. He's then seen in Boston in the weeks and months following the murder. On May 4th, he walks into the police station to get a police report for his insurance company. On May 16th, he's seen in Boston driving around in a black Nissan that was being driven by co-defendant Nico Pledger. And he's then, on May 16th, that's when Lisa is stopped and she's served with the papers. That's when D'Artagnan and Nico are both in that black Nissan. The warrants issue on August 19th, 2016, and less than 2 weeks later, he is apprehended in Georgia. So there is significant, the evidence was certainly probative of the fact that this is a Boston guy who lives in Boston and was in Boston at the time of murder, remained in Boston, the warrants issue, and then he's gone. So certainly that reaches the evidentiary hurdle of being probative of feelings of consciousness of guilt. And then with respect to the prosecutor's statement, the claim is made that this was sort of a backdoor attempt to get in, to use Lisa Lewis's statement against D'Artagnan Pleasure. And I don't think that's what the prosecutor did or said at all. He in the defendant's closing argument, the point was raised that the defendant might have been on vacation, might have been visiting family. There are plenty of reasons. People have lots of different reasons to travel. That's at volume 13, page 48. And then in direct response to that, the prosecutor, in the context of a 24-page oral argument that carefully and meticulously sets forth the evidence of each defendant's individual guilt, he says that he says, despite what the defense counsel says, there is good evidence to know that he knew that D'Artagnan Pleasure knew of the issuance of the warrants. Suddenly, after August 19th, when these warrants issue, they're gone. And he says, how do you know that he was, he says, the defense says, how do you know he wasn't visiting his grandmother or some relative down in Georgia? Well, in isolation, that may be true, but look at it in context of what the other two defendants do. He does not say, look at it in context of what Lisa Lewis says. He says, look what they do. They're all in Boston. They're all from Boston. They've all been seen in Boston. The arrest warrants issue, and they're all gone. They're all gone. They are all apprehended out of state. And that is permissible closing argument.
Let's assume, go ahead, Judge Shin,
Then
you go
counsel
first.
counsel goes on to say that, and what does Lisa Lewis say? And then repeats the statement that she had made to her half-sister. So
he does, but keep in mind, this is a closing argument as to all three defendants. And so he has to address Lisa Lewis and her knowledge and her guilt in the closing argument. But he does state that, again, this statement only goes to Lisa Lewis's state of mind. I need a place to stay because I got warrants out. So she knows. And that's why she's got Nico with her. That's what he says. And that was the evidence, that she knew and she had Nico with her. But he doesn't say use that statement that she knows against D'Artagnan. He says, look at what they all do. Look at what the other two defendants do, not what they say. Look at what they do. And the fact is, they all fled.
Let's assume for just a moment, counsel, that we interpret the prosecutor's statement as, at the very least, inconsistent with the judge's earlier limiting instruction during the course of trial. Does it matter that the argument is in response to something defense counsel has said in argument?
I think it does, because the case law is clear that a prosecutor is permitted to respond to points made by a defense attorney in closing argument. That being said, what a prosecutor cannot do is directly contravene a judge's order. So, he can't, that's a line, that a needle that has to be thread and has to be thread carefully. But in this case, I think it was thread carefully. And I think it also needs to be considered in the context of all of the evidence presented at trial and of the judge's instructions to the jury. And again, the judges, when the evidence of Lisa Lewis's flight came in, there was a contemporaneous limiting instruction with respect to the fact that statement could only be used against Lisa Lewis. Then there's the careful general consciousness of guilt instruction that's given, and that's at volume 13, page 128, 129, which is very careful and very clear on how the jury can consider the flight evidence of consciousness of guilt. And then there's the judge's general instructions, which are repeated multiple times on the fact that closing arguments are not evidence, and that it's the jury's job to evaluate the evidence and be the finders of fact. So with those careful instructions throughout the trial, even if the statement was better left unsaid, there was no prejudice. And I would also point in my remaining minutes to the strong evidence of D'Artagnan Pledger's guilt. Again, his cell phone records show a flurry of calls between him and his brother immediately prior to the murder, which took place right as a party that both his brother Nico and the victims attended was breaking up, and during which Nico was called from one of the party goers' phones multiple times. So there's the connection between Nico and that party. A map triangulating the defendant's cell phone usage showed his presence in the area immediately before and during the shooting. That's Exhibit 219. The defendant's car containing the Sig Sauer, one of the guns used in the shooting, and his wallet with his license, credit card, and cash and cell phone are located at the scene. The car sustained significant ballistic damage. The murder weapon was found next to the car, and a magazine was found directly under the car. Surveillance video from the area showed a man with the defendant's build getting into the passenger side of a Nissan Maxima driving the wrong way down Monroe Street at approximately 3:06 in the morning. That's Exhibits 232, 228 through 235. Eyewitnesses who saw the aftermath of the shooting saw a black Nissan Maxima drive the wrong way down Monroe Street immediately after the shooting, and a man who had been involved in the shooting throws something into a parked car. Inferentially, the gun being thrown into the defendant's car. After the shooting, we have the evidence that he lived, that I've already gone over, about his wallet and the things in his wallet and his cell phone records indicating that he lived in Boston. And then on August 31st, just again, 12 days after the warrants issue, he's apprehended in Georgia. So the evidence of his involvement in this crime was strong. It was a circumstantial case, but it was a strong circumstantial case. And the evidence of his flight to Georgia was certainly probative of feelings of consciousness of guilt and was properly admitted. And again, to the extent there was an isolated error if this court were to find that there was an isolated error in the prosecutor's closing, what the Commonwealth does not concede, there could be no prejudice in light of the judge's careful instructions and the strong evidence of the defendant's guilt. If the court has no further questions, the Commonwealth is content to rest on its brief.
Thank you. I'll just check with the panel. Justice Kinder? No?
Further questions?
Justice Shin? No questions, right? And Justice Shin, I see no questions?
The Commonwealth's ready, but I'm assuming we go second.
Just 1 second. Just wait 1 moment until we're actually live.
Sure. Sorry.
No problem.
And we are live.
Okay, thank you very much. Let me just begin by introducing the panel to you. This morning, I'm joined by Justice Jeffrey Kinder and Justice Suk-Young Shin, and my name is Ariane Buno. This case number is 2019-1716, Commonwealth versus Valentine Soto. Just a brief reminder that the same rules of appellate procedure apply to our remote platform. You each have 15 minutes to present your argument. There is no rebuttal. You can be assured that we've read the cases we've read your briefs and everything you've submitted to us and the pertinent cases, and we're ready to hear your argument. Attorney Weber for Mr. Valentine Soto.
Yes, Your Honor.
Thank you.
Thank you. So Mr. Valentine Soto's case is here today because his arrest and subsequent discovery of cocaine and conviction was based on a search that should have been suppressed. As Your Honor is aware, he was stopped for a traffic citation. While he was being stopped, the police noticed a small knife he had tucked into his pocket, so they took the knife into their possession for safety purposes. Now that was fine, but that's where the action should have ended. The police then instead proceeded to open up the knife. It was upon opening the knife that they observed it was over 2 inches, which is the legal limit according to a city ordinance. And on that basis, they arrested him. And during the arrest, there was a search that resulted in the discovery of the cocaine. But there was absolutely no reason whatsoever to open the knife. Now, they were trying to, there were multiple ways that this was trying to be justified, none of which should have actually happened. One of which is under the idea that it would have been a plain view seizure. Now, as your honors are aware, under a plain view seizure, an object has to be immediately apparent as being something illegal, and it was not here. Now, they could see it was.
Can I just ask you a question?
Of course.
The judge seemed to have interpreted the officer's testimony slightly differently and found that the officer could see the potential, could readily infer that the knife was longer than is permitted to be on your client's person than permitted by the ordinance. What do you say about that particular fact?
Well, to that, I would put it, the way that the officer attempted to justify it is the officer said that he could tell it was over the limit because of the length of the clip. Correct. He never saw that he could see the length of the blade because obviously you can't see a blade as when a knife is folded. He said it was based on the length of the clip. Now, while the clip itself was longer than 2 inches, that doesn't mean a blade itself is longer than 2 inches. In fact, trial counsel even pointed out instances in which a person would have a 2-inch knife with, I believe it was maybe a 6-inch clip. So a clip is.
But if I could interject, isn't it a reasonable inference for the officer to make at the time that the blade will be close in length to the clip in which it is housed?
Close. Well, I think Your Honor said a couple of things that are important here. Inference and close. For plain view, it needs to be immediately apparent. An inference is not immediately apparent. An inference is, it's essentially, I do think the officer had a hunch. He had a reason to think that it might have been more than 2 inches. He certainly had some level of suspicion, but that is not sufficient for plain view. That is not sufficient in order to show that it is immediately apparent as illegal. And that, I feel like, is a very important difference in regards to this case, because it was not immediately apparent. Because again, the ordinance is 2 inches. The knife was anywhere from 2.5 to 3 inches. There's a bit of a discrepancy in the record. One part of the record listed as 2.5, one listed as 3. But even if we go with 3, even if we go with the longer, we're talking about 1 inch. This was not a machete. This was not some gigantic knife where you can immediately tell. This is a very, very small difference. And
if we're talking about probable cause and not plain view, aren't we in the realm of reasonable inferences?
Well, if we move to probable cause, obviously that's a different scenario. And in that case, no, I don't believe there would be enough for probable cause. The only thing that would support probable cause would be the length of the clip. There's nothing else that would indicate that Mr. Valentin Soto had an illegal item on him. He was stopped without incident. He was cooperative with the police. There were no furtive movements. When they asked him for the knife, he handed it over. No arguments, no problems. It was the length of the clip by itself.
And why isn't that enough?
Well, I've not seen any, I guess I would start with, I've not seen any case law that would certainly indicate that's not enough. And even then, I think the idea of, again, because we're talking about 1 inch. So this is not some gigantic knife. The idea that 1 inch, a tiny clip that is slightly larger than the clip, again, not the knife, but the clip being slightly larger, I don't believe that really would give rise to probable cause to search the knife. And I've certainly never seen any case law that would indicate that.
Let me ask you this. Hypothetically, if when the knife was removed, what you say was legitimate to actually remove the knife from the pocket, or you're not contesting that?
No.
Let's say that it was immediately obvious that this is like a 6 or 7 inch knife, all right, by the weight of it or by the looks of it, etc. Then your argument would be less compelling. Is that fair to say?
If it were a obviously gigantic knife, if that were the case, then yes.
I guess that's what I'm trying to get at. Why, in your view, is it important that it has to be an obviously gigantic knife when we're talking about probable cause? There's probable cause to believe the knife is larger than is permissible by the ordinance. A police officer can look at something. I think a layperson can look at something, determine if it's 2, 3, 4, 5 inches long. Correct?
In terms of the length of the clip itself, perhaps so. But I think that when we're talking about such a small difference, I think the officer had at best a hunch. I don't think that that information, because like, again, this is the clip alone. There's nothing else of any kind of information that would lead the officer to believe that there's probable cause. There's nothing beyond the length of a clip. And I think a clip being a teeny bit longer than what a city ordinance would allow, I don't think that rises to the level of probable cause. I think that rises to, at most, the level of a hunch. And I don't believe that a hunch is sufficient in order to justify a probable cause search in regards to this situation. And even beyond the probable cause, well, actually, if there are more questions about probable cause, I wouldn't want to move past that issue if your honors have more questions specifically relating to probable cause.
Could I ask you a question about something that the officer testified? He was describing the clip, and he said, I'm on page 38, it's an elongated object that runs along the length of the knife, pretty much maybe an inch lower than the top of the knife, so about an inch of the knife was protruding. What does that mean?
I apologize that I'm not, off the top of my head, super familiar with that specific inch, because there was no part of the blade itself that was protruding.
He seems to be saying that 1 inch of the knife was visible because it was longer than the clip. Do you have any insight as to what he meant there?
Quite honestly, Your Honor, I do not, and the judge did not refer to that part of the testimony in making the trial court judge in making his ruling. So it does not appear that that specific part of the testimony did not seem to factor into the trial court judge's decision, as far as I'm aware. But even then, if that were to be shown, that's a small bit of knife, and no one's saying it wasn't a knife. I mean, it certainly was a knife. So even if a small bit of the blade was visible, that doesn't change the fact at all. It doesn't. We know it was a knife. It wasn't some revelation in order to find that it has a blade, and that the blade would have been an inch or an inch visible. Wouldn't really change anything in regards to that. So I'm not sure the exact meaning that the officer had in that testimony, nor did the trial judge refer to that specific part of it. But I don't think it sheds any light on the scenario, because again, no one was contesting that it was a knife. That much was just an open fact, which is why it was fine for the police to have taken it during the beginning of the search, because this was at the beginning a safety issue. Certainly not contesting that a knife, even a 1 inch blade knife, is a knife. It is a weapon. It's certainly fine for them to have it with them. And in fact, that's one of the reasons why any type of argument to try to justify this under a safety search, I believe, would fail as well, because there was no safety concerns here once the police had the knife in their possession. I mean, they didn't need to open it up and look at it. They had the knife in their possession. He can't use a weapon that he doesn't actually have. So obviously they didn't have any safety concerns. And even then, opening the knife doesn't actually change anything in regards to the safety. If we'd found out that the knife had in fact been 2 inches on the dot legal limit, or the knife being the length that it was, it's a knife, it's a blade. Opening it up doesn't suddenly give the police more information that it doesn't make them any safer to know if a knife is 2 inches or 3 inches. At the end of the day, it's a knife. They have it in their hands. Mm-hmm. They know that it does present a risk of sorts. So finding out the specific length of the knife doesn't do anything. So there'd be no justification under the safety search type of idea for the purposes in regards to that knife. And the police themselves do fully admit that had the knife been the legal limit, they would have simply issued him a traffic citation and sent him on his way. So there's no question that they weren't going to arrest him. The arrest was because at the end of the day, this conviction is not about the knife. The knife is the justification for the arrest that led to the discovery of the cocaine that is the subject of the conviction. So really, while the knife may have resulted in a city ordinance violation, it's not the primary concern of the case.
Presumably the officer, the officer was going to give the knife back. Yes. So why doesn't that pose a safety concern?
Well, because the knife is a safety concern in general. Stated, it's a knife. We all admit that is a safety concern. Finding out the length of the knife doesn't change that fact. When he gives the knife back to him, if it's a 2 inch knife, when he gives it back to him, it's a safety concern. If it's a 3-inch knife, when he gives it back to him, it's a safety concern. So finding out the specific length of the blade doesn't actually change the level of danger that would amount by handing the knife back to Mr. Valentin Soto at the end of the search. So it doesn't.
That of course presumes that the only justification for opening the knife was for to further protect this officer's safety. Whereas that would be your argument. That's the only justification. Whereas perhaps there's other justifications for opening the knife.
Well, and
which you don't agree with, but I'm just saying that.
Yes, if that is the idea, then yes. And in regards to that, and really that kind of goes to the other issue here is that there's no other justification for opening up the knife because, as stated, it's not immediately apparent as illegal. In fact, the mere fact that they had to open it up before they arrest him kind of shows that fact. And beyond any potential safety reason, I could see no reason why they would need to open up the knife. I mean, it has nothing to do with a traffic citation, certainly. It has nothing to do with why they stopped them initially. I can't possibly, and nor did the police officer testify to there's no other reason to open up the knife. There's no need for it.
I think we see that point. Did you want to move on to your other independent argument with respect to the search before your time is up?
Yes, thank you, Your Honor. So obviously the search, the arrest and the search should have never happened in general, but just for the sake of argument, if the arrest had been valid, there was also no reason to perform the inventory search of the defendant that led the discovery of the cocaine, because that is what the type of search was. It was an inventory search that resulted in the discovery of the cocaine, because before that inventory search began, the defendant asked to give his property to his girlfriend who was at the scene. Now, the police said that they were okay with him giving him stuff, but ultimately they didn't. This wasn't about whether or not they felt like allowing him to do it. Case law has shown, I've cited this in my brief, Commonwealth v. Abdallah, amongst others, that police were not acting reasonably in seizing a bag by the defendant and transporting to the station to perform an inventory search, where in that case—
This is a little bit different, isn't it? I mean, I think in your view, if I understand your argument, you think what should have happened here is for the defendant to be able to turn his back to the police and pull stuff out of his pockets and give it to his, I believe the woman was identified as her girlfriend at that time, and not have the police know what he was doing.
Well, it would have been at least that they performed an inventory search before he even began to give items to his girlfriend. Now, I'm not saying that the police necessarily had to go stick their heads in a corner and not look what was happening, but ultimately, we don't know if they would have seen the cocaine upon him giving items to his girlfriend. Maybe they would have, maybe they wouldn't have, and that really is one of really the issue in regards to this, because it was a small amount of cocaine. This is not some huge amount, so it's possible that
50 grams.
Well, small enough that it is at least possible that they would not have seen it upon giving it.
50 grams in a ball in a plastic bag. That's not that small.
I would argue that it was small enough that it is at least possible that it had not been noticed upon giving it to his girlfriend. Maybe, but the problem here is that we unfortunately weren't given the opportunity to know what would have happened had they not performed this prior inventory search. If they hadn't, and then upon giving his girlfriend they had noticed it, well, that would have been a different scenario we could have addressed. But unfortunately, we could do nothing but speculate at this point as to what may have happened. And that's really an issue because that would just be a speculation. As I see my time's expired, unless Your Honors would like me to, I will rest on my brief.
I'll just check with the panel. Judge Kinder, no questions? Justice Shin, no questions? Okay, thank you very much. Attorney O'Neill? You're on mute. You need to take yourself off mute. There you go.
Can you hear me? Okay.
Yeah.
Good morning, Your Honors. The Commonwealth is here today to ask the court to affirm the motion judge's denial, of the defendant's motion to suppress. And there are a couple of very good reasons for that. One of which is this court has previously, back in '86 in the Miller case, and more recently in 2016 in Justice Agnes's decision in Sanders, have looked at similar fact patterns and determined that a closed knife in a pocket, such as we have here, a closed knife in a pocket can be opened and looked at. And specifically in Sanders, the more recent case, it's very similar to our fact pattern here because there's a Lynn municipal ordinance that is exactly the same as the New Bedford municipal ordinance. And this court in that case determined that it was fine to have opened up the knife. So I would say to the court, this is well tread, or at least somewhat
What do
tread.
you mean by our saying that it was fine to open up the knife? Then that case did not really discuss, did it? Safety concerns or probable cause, or actually focus rather on the opening of the knife. Isn't that right?
Well, but it doesn't take issue with the opening of the knife, and nor did the defendant. And that's where I'm going with this. There were other issues, such as there are.
But here the defendant is taking issue of opening the knife.
Correct. But it wasn't as simple, Your Honor, if I may, it wasn't as simple as saying, well, it's no issue at all. It was discussed. It is set out in the facts, and the court did not quarrel with it at all. So I would suggest to the court that this isn't a new theory. This isn't something unusual. The court has touched upon this. I would also point out, and if I can go out of order for a second, Justice Shin asked a question about the knife being seen in the back pocket. And my brother, I understandably didn't realize that it was on page 2 of the justice's, of Judge Dupuy's findings. That would be the motion judge, in which she said that yes, that an inch of the knife was visible in the back pocket of the defendant as he traveled by on his moped. So I would say to the court that in terms of the knife, one, you have the precedent already to act upon this and uphold the trial judge's decision, motion judge's decision, excuse me. But also two, my brother spoke at length about, plain view and what have you. And the Commonwealth's argument has been, and is set out in its brief, it's on a probable cause standard, and of course also a safety standard. And just to be clear, my brother on page 11 of his brief doesn't argue with the stop, does not argue with the pat frisk, does not argue with motioning the defendant to exit, or in this case, get off the moped. Mm-hmm. All of that is conceded to. What is not conceded to, obviously, is the opening of the knife. But as argued in the Commonwealth's brief, the knife gets to be opened for two reasons. One reason is it's an incidental, how shall I put this? It's an incidental look at what was the item that prompted probable cause, or that established probable cause in this case. And I would suggest to the court, as I think the court has already suggested to my brother, that probable cause is not beyond a reasonable doubt standard here. What you have is a reasonable basis, a probable basis that a crime has been committed or is being committed. And in this case, Detective Kubik had that. He sees the knife go by him, he sees the defendant drive by him on the moped. And what does he see in his back pocket? For all the world to see, I might add, is an inch of the knife. And it is clearly a knife to the detective. So when he pulls over, I shouldn't say pulls over, because the defendant, to his credit, stops. He pulls his moped over to the side, he gets off the moped. But at this point, the detective has the right to look at the knife. My brother makes the argument about,
and what do you think is your best argument when you say that the defendant had the detective rather has the right to look at the knife? Is that because there's probable cause to believe that the knife is over 2.5 inches, or because he can open the knife in order to protect the safety of himself and other fellow officers?
It's hard to choose which is better of the two. I would say that it's part of the pat frisk. So in that it's part of the pat frisk, that isn't, at least that part of the pat prior to that is not contested to. So as part of the pat frisk, I would say, yes, it definitely would come in under an argument that it is a safety concern. But I think actually the stronger of the two arguments, although I think they're close, the stronger is the probable cause one, because now you have a detective who has seen a knife in the back pocket of this gentleman, and he has pat frisked him, taken the knife, and gets to open it. And as he explained in the motion to suppress hearing on page, I want to say 50, If it had been less than the ordinance, if it had been a size less than the ordinance, he would have returned it to him. But in this case, it wasn't. And in this case, he was able then to arrest him, which, and I can jump around if the court wants, but if I might, just for a moment, factually, it does, how shall I say, it does not make ludicrous, but make kind of silly the argument that the defendant would have been able to hand over the drugs or whatever items he had on him, which turned out to be drugs, to his girlfriend. Because once you know that this is a knife, and it's a knife that is in violation of the ordinance, he's cuffed on pages 17 to 18 in Detective Kubik's testimony at the motion to suppress. He cuffed him. So now what my brother is asking is that the cops uncuff him so he can take the stuff out of his pants and hand him over to the girlfriend, which, you know, on its face, I would suggest to the court is ludicrous. But anyway, having said that, I'll go back to the probable cause piece. The detectives had every reason to search, do a pat frisk of the defendant. When in the course of the pat frisk, they see the knife. They don't even have to frisk him to see the knife because, you know, when you look at reasonable expectations of privacy here, in the brief, it goes on at length about whether or not there's an objective expectation of privacy that society would recognize here. You could even start with the subjective expectation of privacy. The defendant himself had a knife open to the public in his back, just to be clear, had a knife visible to the public in his back pocket as he's driving on a moped on city main streets. Well, North Front Street's not quite a main street, but it's not a path. It's a legitimate street in the city of Fall River. So yeah, I would say to the court that they had the probable cause to go forward. And my brother makes a comment about hunches. Well, there was far more than hunches involved here. For instance, the detective testified that the defendant was and I quote, validated member of the Latin Kings, which Her Honor also endorsed in her findings. And she pointed out that the Latin Kings, which came out in testimony, is a violent street gang which has a strong or significant presence in the city of New Bedford. So you have that. You have Detective Kubik, who 2 weeks prior on that very same street, North Front Street, but I believe it happened inside the defendant's apartment, on that very same street is arresting him for, I believe he testified that it was for a drug offense. So you have that. So you have a validated Latin King, you have him being arrested 2 weeks prior on drug offenses, and you have him with a knife in his back pocket. I would say what does
the prior arrest for the drug offenses have to do with this, or that have to do with establishing probable cause to determine whether or not the knife it exceeds the requirements under the ordinance?
In this case, I don't think it's not an element, certainly, of the requirements under the ordinance. What it does is it fleshes out the specific and articulable facts that the detective had. And in this case, he's got himself a drug dealing.
But you're not suggesting that there was any reasonable suspicion, let alone probable cause, to search him for drugs.
No, we're not suggesting that. No, that in this case, it was
because almost, there's no justification to search him for possession of illegal narcotics, correct?
Commonwealth agrees completely, Your Honor. There's no justification to do that. As a matter of fact, they weren't doing that. It's a happy accident, shall we call it, that they ended up with the drug.
I guess they were out there investigating individuals for street level narcotics dealing, right?
That's true. Kubik was in the gang unit, and Lizotte and I cannot pronounce the other detectives' names were both in the Vice Squad unit. So yes, they were absolutely out in the city of New Bedford, which is not an unusual thing. Not to denigrate New Bedford at all, but it's not unusual for major cities or good-sized cities to have drug problems and to have these particular officers or any particular officers looking out for whether or not there's drug dealing going on. So no, that's not unusual. What is important, we would suggest to the court, is that in this case, this isn't just a hunch. There are drugs around here, we're going to grab this guy. No, he is the engineer of the results here. He is the one who had the knife sticking out of his pocket. He is the one, and it's not even contested with. He is the one who said to the officers, "Hey, can you, I want to transfer my property what's in my pockets over to my girlfriend." Well, that's what would you expect the officers to do here? And case law does not demand that they not look at what they're taking out of the defendant's pockets and hand over to the girlfriend.
Would the officer have been justified in arresting the defendants without opening the knife?
Yes. I think in this particular case, because of the probable cause that they had based on the clip on the knife, that yes, they had sufficient grounds in which to arrest him. Opening up the knife confirmed it. Again, I don't want to make the officers look like they're the best friends of the defendant, but in a way they were, because by opening up that knife, and on page 50 of the motion to suppress, motion to suppress hearing, Kubik says, hey, if it wasn't the right length, if it was less than, what's prohibited by the ordinance, I would have given it back to him. End of story. So in this case, yes, he had probable cause. It was sufficient for him to arrest. And when he opened the knife, it confirmed it.
Assuming for just a moment that the defendant had his personal items in a backpack rather than in his pockets, and explained that he wanted to give his backpack to his girlfriend, would the police have been justified in searching the backpack?
Absent some other cause to look at the backpack, no. I think that would be Your Honor's case. You were on the panel in Nicolau, where there was a backpack and a grandmother in that one. And certainly the police had permitted some items, I think it was a music box of some sort, to go to the grandmother it was at the grandmother's house. They were outside in the car. The items were in the car, but the grandmother was available to take the items. And the police let her take one item, but did not let her take the second item. And in that case, the court found that wasn't sufficient, that the motion to suppress should be allowed. And we would, not to say that we would disagree with the court, but that certainly doesn't hurt our case at all, because this isn't that case. So if it was in a knapsack, then yes, we've got a whole different issue going on. And I would point out that I believe it was Justice Buono, in an earlier case of 128, I think it was January of this year, the Can case, that distinguishes Nicolau on those grounds. It's a different set of facts. So no, the Commonwealth is not saying we could have taken his backpack unless we had reason to believe he had a gun or more than reason to believe, unless we had probable cause to believe that he had these items in the backpack. No, in this case, as I said earlier, he's the engineer of his own demise, shall we say here. He's the one who put the knife in his back pocket and went down on a moped with no helmet on, the main drag in New Bedford, and the police saw him and pulled him off.
Can I ask you, so if the officer had eyeballed the clip and thought it was 2.5 inches or shorter, would he have been justified in opening the knife?
If he thought it was less than the ordinance, I would suggest no, he would not be.
Why wouldn't your argument about safety concerns apply then?
It could. It absolutely. Oh, I see what you're saying.
Right. So, I mean, it seems to me your argument has to depend on probable cause and not officer safety concerns.
Well, I mean, in the brief, both arguments are made. And I would suggest, I was asked earlier by Justice Buono, which is the better argument of the two. And if I had to choose, as I said, I thought they were close. If I had to choose, I'd say the probable cause one. But that does not preclude an argument on safety. So if a knife is 2 inches long, why is the officer more safe after he's opened it rather than just leaving it closed? Okay, maybe I misunderstood, Your Honor. I think if I'm hearing you correctly, that is it your belief that the Commonwealth has conceded that there isn't a safety argument here to be made? No. I'm probing the argument because you seem to be suggesting that the officer was entitled to open the knife regardless of how long it was based on safety concerns. And I'm just asking if your position is if the officer thought the knife was under 2.5 inches, whether he'd still be justified in opening it. Right. What I answered earlier had to do with probable cause. What I'm answering now for safety purposes is sure, I think the officer should have been able to open the knife. Now, my brother points out, and rightly so, that once they have possession of the knife, it isn't a safety concern any longer. That could be so, but in this particular case, I think by requiring the police officers to not be able to, how shall I put this, not be able to do everything possible to protect themselves in this case, then I think that's asking too much of them. But
Actually, your time has expired, so if you want to just finish your answer, that would be fine.
okay, the Commonwealth would just argue that, would ask that the court affirm the denial of the motion to suppress on the grounds that we have argued the probable cause and the safety, which came into play at different parts in the stop and the search.
Okay, and before I let you go, I'm just going to check with Justice Shin to see if she has any follow-up questions. I see none, and Justice.
And we are live.
Thank you very much. Good morning. I'd like to begin by introducing the panel to you. I'm joined today by Justice Jeffrey Kinder and Justice Suk-Young Shin. The case we're about to hear is Commonwealth versus Jake Almeida, 2020-0096. Just briefly, I want to remind you that the same rules of appellate procedure that apply to oral argument in the courtroom apply here. You each have 15 minutes and there's no rebuttal. Since I know that both of you have appeared before our court before, you will know that we've read your briefs and we read everything that you've submitted to us. And so we recommend you get right to your most important issues. With that preamble, I'll turn to Attorney Nadeau to begin your argument.
I think it's Mr. Smith.
Oh, I'm sorry. I apologize, Mr. Smith.
Thank you, Your Honor.
Thank you, Judge Kinder.
Good morning, members of the panel. May it please the court. My name is Joseph Smith. I represent the defendant in this matter, Jake Almeida. If it pleases the court, I'd like to flip the chronology of my argument, if you will, as it appears in the brief. And I'd like to focus initially on the defendant, Mr. Almeida's motion for a required finding of not guilty and why the court erred in denying that motion. So, as the court's aware, Mr. Almeida was pulled over driving his mother's car, and during the course of the traffic stop, the police ultimately found a firearm in the locked glove compartment of that car. So in this instance, the Commonwealth is proceeding or did proceed under a theory of constructive possession. And so under a theory of constructive possession, the Commonwealth is required to prove beyond a reasonable doubt knowledge coupled with the ability and intention to exercise dominion and control over the firearm itself. And as the court's well aware, mere presence in an area where contraband is located is not enough to prove constructive possession beyond a reasonable doubt. As the cases referenced, there at a minimum needs to be a plus factor in order to tip the scales in favor of sufficiency. And at the outset, I'd note also that the inferences, I should say, that the fact finder is asked to draw, they aren't ones that can merely be plausible. They have to bear the weight of proof beyond a reasonable doubt. And I think in this case, the Commonwealth fell well short of that. So there are many.
What if I could interject a question? What about the presence of the keys that would unlock the glove box, which I understand were in a cup holder within easy reach of the defendant?
So, Your Honor, yes, thank you. The distinguishing factor, I think, or what should be noted with regard to the keys is this was not a key that was immediately apparent as such. So this is a unique sort of key in the sense that it's not simply a ring of keys where one starts the ignition and then there's a separate key that would appear to open the glove box. This was what is referred to in the transcript as a fob type of key, I think a remote starter, and seamlessly contained within that fob is what is referred to as a valet key that opens the glove box. So one could infer that it's not immediately apparent that the key that opens the glove box is apparent as such to the driver, someone who's presumably been loaned the car and is driving it on a provisional basis. But I think even if Your Honor is inclined to believe that the defendant that's a factor that could weigh in favor of sufficiency, I think that we still have to consider the idea of intent to exercise dominion and control, and even to the extent that which I would dispute, that there's evidence that there's sufficient evidence that there was knowledge and ability to exercise dominion and control. The Commonwealth still has a very large problem with regard to intent to exercise dominion and control. They haven't demonstrated any plus factors, I think, that would establish that there's an intent to exercise dominion and control. In this case is, I think, in Commonwealth versus Romero, the evidence is much stronger that a gun in plain view was present in the car, that the defendant was a registered owner of. It was being passed around. He knew of it. He potentially had the ability to exercise dominion and control over it, but the Commonwealth or the court reasoned that there was not sufficient evidence to establish beyond reasonable doubt that the defendant had the intent to exercise dominion and control over that item. Now, the Commonwealth, in its brief, cites Commonwealth versus Summers as a case that would support its argument that, in fact, there was sufficient evidence that constructive possession was established. I think that case is readily distinguishable from the present facts, and there's also a rather astute dissent that was authored by Justice Vono in that case that I think is persuasive as well. But just in terms of even to the extent that the appeals court would consider that to be a case that should remain good law, there are far more incriminating factors as it relates to the defendant in Smith. He basically was dishonest with the police in that he concocted a ruse indicating to the police that his child had been hurt and that he had to leave. There was another passenger in that car that then began to become agitated and sort of gesticulate towards a backpack that was in the car itself that ultimately contained a firearm. When that occurred, the defendant ran away. When he was ultimately arrested a month later and learned of the nature of the charges based on the warrant, he said something to the effect of, well, why wasn't the passenger arrested? He had a record just as long as mine, and he fled as well. So there were far more factors that were.
But here, the defendant says unprompted, this isn't my car. He denies, I think the evidence can reasonably be construed as he denies knowledge of where the keys are to the car he's just been driving, and he has control over the car. So why isn't that enough?
So, Your Honor, I would disagree in the sense that the record doesn't indicate that he denied knowledge of where the keys were. One of the detectives, I believe Barbosa, asks the defendant, Mr. Almeida, whether he had the keys to the glove box, and he stated that he didn't have them or didn't realize where they were. That's different than saying, I don't know where the keys are, period. And then, in fact, the keys to the car are
no, but I mean, why can't you infer that he's trying to deflect attention from the keys, right? Because he's just been driving the car. So he knows where the keys are, yet he's trying to say, I don't have the keys, I don't know where they are. And that reflects that he knows that the key to the glove compartment is on that same key ring. Why isn't that a reasonable inference?
I don't think that is a reasonable inference beyond a reasonable doubt, which is essentially proof to a moral
what about coupled with the this isn't my car, unprompted, and he has control over the car?
That is, at best, very meager consciousness of guilt evidence, which is not enough to establish proof beyond reasonable doubt. And I'm not even sure that it would go that far. It's not a false statement to the police. It's in fact a true statement. And but
it's unprompted. I mean, it is a little bit unusual that he says it unprompted as he gets out of the car. This isn't.
Well, I mean, it to some extent should be understood in the context of the traffic stop itself. It was what was at the outset a routine traffic stop, and then the officer notices that the backseat passenger has a large amount of marijuana, and so he's ordered out of the vehicle. I think that's. that should be sort of calculated into the analysis. But I mean, that's not just merely stating to the police that the car is not his. Isn't, I think, enough beyond a reasonable doubt to tip the scales in favor of sufficiency. And it's not even a false statement. I mean, and the defendant's demeanor doesn't change, which is the cases have shown is a factor that weighs in favor of sufficiency when it comes to a determination of whether there's enough evidence to establish beyond a reasonable doubt that a defendant constructively possessed an item. I mean, we need to look at the absence of all these factors. The gun's not in plain view. The defendant doesn't make an effort to flee the area. The defendant or Mr. Almeida, I should say, doesn't sort of make a false statement to the police, merely indicates to the police that the car is not his. So I think that those factors weigh against determining that there's sufficiency of evidence. I think it's a case of mere presence. If we had other factors that could establish, for example, a special connection with the area itself. Well, let's assume, for example, as some of the other cases that the Commonwealth cites, that, for example, there were letters or pay stubs or other items that were addressed to the defendant in the glove box itself. That might tip the scales in favor of sufficiency. But even to the extent that that it could be said that by saying the car's not his, he's trying to deflect attention from the fact that from the glove box itself. That implies knowledge, but that doesn't prove beyond a reasonable doubt that he had the intent to exercise dominion and control over the item, and that's important. And that's an important aspect of the analysis that needs to be taken into account. The Commonwealth simply hasn't established or didn't establish a trial beyond a reasonable doubt that there was enough evidence that could support an inference that the Commonwealth, at a minimum, or excuse me, that Mr. Almeida, at a minimum, had the intent to exercise dominion and control over that firearm that was in the glove box, even to the extent that he had had knowledge that it was there, or maybe had an inkling that something was there that might be contraband, and he had the ability to access it with the key itself. That's not enough under the analysis to prove beyond a reasonable doubt that the defendant, Mr. Almeida, constructively possessed the item. Given that my time's running short, if I could transition or pivot to my suppression argument, as it relates to the motion to suppress, my argument is that Mr. Almeida's motion to suppress should have been allowed. We have here a routine traffic stop for what appears to be an inspection sticker violation. The police pull over the car that Mr. Almeida is driving, which is a Mercedes with tinted windows. When he approaches the car and speaks to the driver, Mr. Almeida is completely compliant. There's no evidence that Mr. Almeida was impaired, that his driving was problematic. They don't notice an odor of marijuana. Early on in the encounter,
Smith, let me interrupt and sort of jump ahead a little bit here. If we credit the judge's finding that there were 6 individual bags of marijuana seen in plain view of either 1 ounce or 2 ounce quantities, why wouldn't the officer at that point have had probable cause to search the entire vehicle for additional drugs, including any compartment within the vehicle?
So, Your Honor, I think that it's not immediately when we say plain view, it's plain view to whom. So from the officer's vantage point, and even then, when Mr. Almeida rolls down the back window, the tinted window, he notices on Mr. Godoy in his lap there's approximately 1 ounce of marijuana, which would seem to be that's under the state of the law now, and at the time that these events took place, was a legal amount of marijuana to possess. And so that's in his lap. That, I guess, arguably is in plain view. He then asks so again, he has to ask Mr. Godoy whether there's any other marijuana in the car. He doesn't see it himself standing there by the window looking at Mr. Godoy. He asks Mr. Godoy, is there any other marijuana in the car? And that's when Mr. Godoy looks down to his feet and there's a shopping bag. Or the evidence is unclear whether the shopping bag itself was transparent, whether it was a shopping bag that couldn't otherwise be seen through. But in any event, it's a shopping bag with other larger bags of marijuana located inside.
To Justice Kinder's point, the finding of the judge is that the officer could see those additional bags in the shopping bag. And I don't think you're arguing that finding is clearly erroneous, are you?
I'm not necessarily arguing that it's clearly erroneous, but just because the passenger in the vehicle is in possession of a large amount of marijuana doesn't necessarily give, under the automobile exception to the warrant requirement, the police carte blanche to search the entire vehicle under these facts, because the marijuana itself is completely localized to Mr. Godoy, and there's no evidence even that Mr. Almeida is necessarily aware of the fact that there is this amount of marijuana in the shopping bag of Mr. Godoy. And the cases that I cite, Pena and I believe it's Alvarez, these are cases, Alvarado, I should say, excuse me, 420 Mass 542. These are cases where other occupants of the vehicles in question are in possession of contraband. And yet, because there's no specific connection to the vehicle itself as it relates to the contraband, there wasn't probable cause to search the entire vehicle. And Alvarado in particular is important. That's 420 Mass 542. The defendant in that case is found to be in possession of cocaine. He's the occupant of the car is found to be in possession of cocaine, and that didn't give the police probable cause to search the rest of the vehicle for contraband, even though the driver of that car was the defendant, is then making furtive movements toward a box in the vehicle itself. So for those reasons, well, just briefly, so just, I guess, remaining on that point, though there was the Mr. Almeida's motion to suppress, in my view, should have been allowed. So my time seems to have expired if the justices have no further questions.
You're down to 3 seconds. You're just about at the time you expired. And I'll just to see if they have any further questions from the panel. Justice Kinder? No. Justice Shin? No. Thank you very much for your argument.
Thank you, Your Honor.
Okay. And now we'll turn to Attorney Nadeau.
Thank you, Your Honor. Good morning to the court. This is Stephen Nadeau on behalf of the Commonwealth. I'll begin with the suppression issue since that's where my brother ended. I'll note that the motion judge found that the amount of marijuana that the officer saw in plain view was an amount consistent with distribution. And certainly that's borne out by the facts. The officer initially sees the 1 ounce bag on the rear passenger's lap, and without having to manipulate the car or lean into the car, he just follows the rear passenger's gaze to the floor of the car, where he sees 7 additional ounces packaged in separate quantities, as if for sale or consistently with distribution. So that all seems pretty clear just on the face of the testimony. And so there, certainly the officer has probable cause to believe that this car contains evidence of possession with intent to distribute. And part of the underlying rationale of the plain view doctrine is that an officer seeing something in plain view, evidence of contraband or evidence of criminal activity, does not have to simply accept that this is the only evidence that remains in the car. So once they see the contraband, case law well developed over the years says they can search the rest of the car and compartments within it. And then that gets them then into the glove compartment where the gun that underlies this conviction is found. If the court has no particular questions on the suppression issue, I would turn then to the sufficiency on the possession point. Here, this is a case where the defendant obviously had the ability to control the contents of that glove compartment because he was driving a vehicle. The keys to that glove compartment were right next to him. And so he had clearly the means readily at his disposal, at his right hand, to access the contents of that glove compartment. What supports the ultimate finding that he not only had the ability, but knew how to access that glove compartment and knew that a gun was inside it, was that this was, although it was maybe not registered to him, it was his mother's car. He shared an address with his mother. It's not like they lived in two separate places, and maybe there was plausible deniability that he was just borrowing it for the day. In fact, this is consistent with kind of being a family car, or at the very least, a car he was very familiar with. I know my brother in his argument referenced that the key was not apparent as such immediately because it was a fob. And I think the question there is not apparent as such.
I can interrupt you for a moment. Maybe it's not so much knowledge and ability, but intent to control the object. What would be the evidence? How would you summarize for me the evidence that the defendant intended, the issue of intent?
So I think, again, it's not
exercise dominion and control.
Sure, it would be the fact that he had kept the key to the glove compartment right with him. The fact that the circumstances of the arrest, although not convicted for related offenses, but the fact that there was a amount of marijuana consistent with a criminal enterprise in the vehicle indicates that he was sort of, well, he was acquitted on this. I don't necessarily want to go down that road, but he wasn't just out for a ride with some friends. There was other stuff going on in the car. And then the fact that as soon as the police get him out of the car, he immediately says, "This isn't mine," which, and the record shows that was unprompted. And the fact that, granted, well, technically true, because it is registered to his mother. He also apparently lives with his mother. It is kind of a suspicious thing to say unprompted about a family vehicle. And then on top of that, when asked about the keys, he says, I don't know where they are. And in fact, they were right next to him the whole time. These keys that it's a car that's registered to his mother at the home where he lives. The idea that the court would not have to accept that he is not familiar with what this key does and what it has access to. And the fact that he lied or dissembled about it is evidence bearing on his intent.
So does the marijuana found both in the back seats and in the glove compartment, in your view, does that add anything to the calculus?
Yes. So the fact that it connects what's going on in the passenger compartment of the car with what's found in the glove compartment. So these are not unrelated things. The defendant is connected with marijuana by a substantial quantity of marijuana by his presence in the car in circumstances that make it unlikely he's maybe not criminally culpable, but not unaware of its presence, and that there's then marijuana found right with the firearm. Certainly casts it in a more incriminating light. He's aware of the marijuana in the passenger compartment. He's aware of the marijuana in the glove compartment. He's aware of the gun in the glove compartment. And in fact, possesses the gun in the glove compartment. And I think that, it's a fairly straightforward set of facts. There's no indication that, everyone here seems to have been quite cooperative with the officers. Sorry, I'm just trying to find my word here.
All right. Take your time.
But it is just a straightforward set of facts. He's in this vehicle, in these circumstances where the key is right next to him. He has the ability to access that vehicle. He behaves in a way when stopped that is suspiciously trying to disavow his own knowledge of what's in the vehicle in a way that inculpates him with the knowledge of what's going on in that vehicle. And under those circumstances, we do believe the evidence was sufficient to sustain his conviction, sufficient to show his constructive possession of the firearm.
I'm sorry. I think you've concluded your argument. I don't want to cut you short, but I'm going to check with the panel to see if they have any additional follow-up questions they would like to ask of you. Justice Kinder, questions on your
No.
behalf? No.
No.
Justice Shin? No. And I don't have any further questions either. So we'll take the case under advisement.
And we are live.
Thank you very much. Good afternoon, and thank you both for your patience and for participating in the oral argument today via this remote platform. Let me begin by introducing the panel to you. I'm joined today by Justice Jeffrey Kinder, Justice Suk-Young Shin, and my name is Ariane Buno. This is the last case we're going to hear today, and the case is Commonwealth versus Alvaro Calderon Huerva, 2019-0605. Just let me remind you that you each have 15 minutes to argue, just as if we were in a courtroom. The same appellate rules of procedure that regarding oral argument apply here, and there is no rebuttal. You can be assured that we have read your briefs and everything else that you've submitted to us, and so we urge you to go ahead and get right to your best arguments. All that said, I'm going to call on Attorney O'Meara for your argument first.
Thank you, Your Honor. May it please the court. My name is Attorney Robert O'Meara, and I'm representing Alvaro Calderon on his appeal. Your Honor, relevancy of any evidence depends on whether such evidence has a rational tendency to prove any issue made by the pleadings or any other incidental issues developed in the course of a trial. It's Commonwealth versus Booker. The admittance of the photograph in this case, the offending photograph in this case, as I've argued, is not at all relevant, and that should not have been admitted. From the record, as you've read, the victim's age was already in evidence. In the Commonwealth's brief, they stress pubertal stage of development. Now, I don't know what relevancy that has, Your Honor. I don't think it has any relevancy. The statute doesn't address the pubertal development of the victim. I think the only purpose was to, I don't know, infer to the jury that my defendant was some kind of lewd individual that committed these acts to a young person, a young woman who was shown in the photograph that came into evidence. I just don't see that that proved any material issue at trial.
Attorney, I'm just going to interrupt for a second and ask you, when you keep your head back a little bit and up, we can both hear you better and see you better. Just that's fine. Just, no apologies necessary. This is a new format for all of us, but we hear you much more clearly when you're in that position. Thank you.
Mr. O'Meara, let me follow that up with a question, if I could. You mentioned earlier that there was already evidence of the victim's age before the jury. Doesn't the Pena case, which is cited in the Commonwealth's brief, stand for the proposition that it doesn't matter if the photograph is cumulative, as long it still has some relevance as to age and is therefore admissible?
Yes, Your Honor. I read that. I guess I respond by saying if it is relevant, and I think the probative value was certainly outweighed by the prejudicial effect.
Okay, then
I would say outweighed versus substantially outweighed. So there are cases on that.
Let me follow up with another question then. The judge found that there was nothing about the photograph itself that was inflammatory. We have, of course, looked at the photograph, which appears to be some sort of portrait, even a professional portrait, perhaps. What is it about the photograph itself that you think is inflammatory?
I just think the way she looks like a 7-year-old, and I think that's inflammatory. It is somewhat probative, but it's more prejudicial than probative in this case. I hate to repeat myself, but even if it was relevant, I think that the prejudicial effect was much worse than was worth the probative effect of entering it into evidence.
All right, thank you. Anything further you want to say about the photograph, or do you want to move on to your other issue?
Well, Your Honor, for the other issue, I would like to, unless the court has any questions, I would like to rest on my brief.
All right, I'll see whether or not we have any additional questions. Just one moment. Justice Kinder, any questions on?
Yeah, I actually do have a question, Mr. O'Meara. You rely pretty heavily, and trial counsel relied heavily on the opinion of the forensic psychologist that the records that were sought would, quote, likely, close quote, involve conversation or statements about the alleged incident. Isn't that the use of that term likely the kind of speculative language that the SJC rejected in Seeley in a case similar to this?
I think that could be argued, Your Honor. However, I think under the circumstances, I thought that there was other things, other material facts in that affidavit that maybe pushed it over the edge of being more like, I guess, more likely than not. I guess I don't know if that's appropriate under the case law, but that was my thinking.
All right, thank you.
Just let me check with the rest of the panel before you rest on your brief. Justice Shin, did you have any questions?
No, thank you.
No, okay. I don't actually have any questions either. So we'll take your the rest of your arguments on your brief, and we'll turn now to the Commonwealth. Attorney Doherty.
Thank you, Your Honors, and may it please the court, Andrew Doherty for the Commonwealth, and I believe watching today on the YouTube stream is Assistant District Attorney Audrey Mark, who was the trial attorney who brought this case to trial. I'll start with the photograph. It was not an abuse of discretion to allow the photograph to come in. I described two different ways in which specifically this photograph was relevant in my brief, but I don't want to lose sight of a third, more generalized concept, which is that children age differently. There are different ways that a child is going to understand the world, relate to the world, remember the world, and describe the world based in part at what stage, how old they are, not in terms of age, but in terms of their development. And so as a broad general principle, having the jury really get to see what this child looked like when these sexual assaults began helps them understand how the child related to the world, and that's not something that can that's not something that can be easily accomplished by the imagination, given the fact that unless you're somebody who has exposure to many 7-year-olds, given that children age at different rates and develop at different times, having that and recalling also that at the time she was testifying, she was about 2 weeks away from her 10th birthday. So really there's almost a 3-year difference when these changes have been occurring. It was helpful for the jury in evaluating her testimony at almost age 10 to
Mr.
understand.
Doherty, let me stop you. I think it's pretty clear why a photograph would be relevant to age, which is an element in this case. It's not clear to me how one's understanding of the world or one's stage of development would be relevant.
I would say that as a 7-year-old at a particular age, it is going to have a different way of evaluating what's occurring. As a child matures and ages, there's going to be a different way to understand, how your parents are talking to you, what your friends are saying, that sort of thing. And so although, that's a broad general principle, but I think being able to say this is a young child, if that's what the photograph depicts, compared to this 10-year-old who's not testifying for me, if that assists the jury in helping to understand what this witness is testifying about. I wouldn't be saying that if this was a 40-year-old discussing something that happened when they were 37, but when those changes are occurring, it is affecting brain development, and social development. And I think that's important for a jury to understand. In this particular case, there were two additional very specific reasons why this was relevant. And the first was with the testimony of Dr. Block. She discussed that a child's decision to disclose a sexual assault may change depending on the age of the child, not as a number, but as at what stage they're in their social and emotional and physical development they're in. Also, Dr. Newton discussed the physiological trauma that takes place or lack thereof, which may take place, an experience of a sexual assault that a prepubertal child will experience that a child that is more developed would not. And by seeing a photograph at the time, rather than imagining an age, the jury was better able to understand at what stage the victim was in this case. And I would point out,
particular argument wasn't before the trial judge, was it?
The ADA mark described the child's size, and I wouldn't parse that too closely. I think that is the relative size of the victim and the assailant aren't, that's an awfully specific way to consider size. And really, I think, given that there's growth involved with puberty, that size is how she defended it, and I think that's how she described it. The final sort of remaining part there is just that, not all jurors are capable of understanding what a 7-year-old looks like. And that it is more valuable to have a visual depiction of the child to help jurors, say, who don't have children of their own, understand what it means to be 7. So I think it's all relevant for those parts. Unless there's any other questions about the photograph, I would turn to the Rule 17 motion.
Mm-hmm.
So with respect to the Rule 17 motion, the defendant does have a burden here. And Judge Miller did not abuse her discretion in denying access to the records. And if you look at the documents which were filed in support of the defendant's Rule 17 motion, every one of there's no affirmative facts that can be found based off of those. It is entirely speculative and based on hypothesis. And if you read it carefully, that the doctor who's the affiant on one of these things, doesn't even say that it's likely that the victim discussed this. It's that it was likely questions would be asked of the patient about the chief complaint. And so when you're sort of gauging, and when Judge Miller is gauging whether there was a factual showing that she could base her determination on, there really is none.
Let me ask you a question, Mr. Doherty. These motions, as you know, come up frequently in the Superior Court, and absent the victim herself saying, I discussed this with my therapist, or the therapist saying, I discussed this with the child, how would a defendant ever meet his burden of accessing therapy records?
So the case that I've read is Commonwealth v. Laborde, where the victim disclosed to a psychologist or somebody who was presumptively privileged, and that person then just went forward and brought it to the, and made the required disclosure, the statutory disclosure.
Well, so that's one of the circumstances I just mentioned. The therapist themselves acknowledges. Is it your position that direct evidence of such a conversation must exist before the records can ever be accessed via Rule 17?
I would say this. It needs to be more than what the defendant did in this case. If the balance that's being struck here is between the presumptively privileged, statutorily confidential records of a mental health provider to a child sexual assault victim versus the defendant's right to due process. And all the case law since the Dwyer Protocol, although it reduced the Bishop-Fuller Protocol in protecting these records, continued to stand for an idea that it needs to be more than a speculation. So could circumstantial evidence establish this? Perhaps, and that's not what was established in this case, and certainly the judge didn't abuse her discretion in so deciding. And I recognize that it is a higher burden. I don't ignore that, but I think it is a higher burden by design in order to protect what's an extraordinarily important relationship of privilege between a survivor and her therapist. I'd like to really turn in some part to an issue that may not be germane to the ultimate decision in this case, but is worth discussing. And I mentioned in my brief at the end, which is that the trial attorney in this case, having lost the Rule 17 motion and failing to establish relevance, then issued a trial subpoena for the exact same records.
This issue was not before the trial judge, correct?
That it was raised at the time of trial through a motion to quash. There was no new motion to request these records using Rule 17-2. Rather, these records were summons to court directly by a trial subpoena.
And you haven't appealed the trial judge's decision with respect to that, correct?
So the judge did order the motion to quash, and the records were quashed. My concern is that, and the trial ADA did ask for sanctions for an abuse of the trial subpoena power.
But again, the judge did not rule on that, so there's nothing before us with respect to that.
She did not. She did not. And as I said, this may not be before the court, but should the court be considering this, I'd ask the court to do what they can to discourage this practice. I cannot see how it's defensible, and the risks associated with it to the integrity of the Commonwealth's case are enormous. Not
Mr.
to mention,
Doherty, it seems to me that the onus was on the Commonwealth to take action in the trial court to bring this issue properly before us, and we generally don't comment on matters that are not appealed.
I understand that, Your Honor. I understand that, Your Honor, and it's hard to litigate these things, and it is difficult to bring something like that towards the court because it would require us to establish. I suppose that the judge wouldn't allow sanctions, and we then appealed her decision not to sanction the defense attorney. But I suppose it's hard to find an appellate record that will allow anyone other than a rules committee to discuss why this is an inappropriate practice. And so I appreciate that challenge. I also, just given the gravity of what the trial attorney did in this case, just ask the court to consider commentary on it.
I have no further questions.
All right. Justice Shin, do you have any further questions for the Commonwealth?
No.
All right. I actually, my timer indicates that you only have about 2 minutes left, so I don't want to cut you short, but I would picked up the timer when I saw we had some issues with the screen here. Have you concluded your argument, sir? The panel has no further questions for you.
I have, Your Honor. I have nothing further to say other than what's in my brief. Thank you.
Okay. All right. Well, thank you both very much. Thank you again for participating in this remote platform. And we'll take the case under advisement and get an answer to you as soon as possible. And on behalf of the panel, we want to wish you and your families that you stay safe and healthy during the pandemic. All right. Take care.
Thank you, Your Honor. Thank you.
Thank you.
Hello, Patricia.
But you're on mute. We were going to say hi to you, but we can't hear you yet. We'll wait for you.